I know we're on Tuesday, but hopefully everyone had a good weekend. Had some little bit interesting weather, that a lot of wind down south. I know we had some snow that didn't stick on up north, but hopefully we get a little more moisture. So we're going to continue what we were talking about last week, as Ken introduced the code of ethics. We're going to kind of try to finish what was discussed, and again, answer any questions that people may have as people are logging in to jump into this. The key thing I want to at least mention about this stuff is, especially today's, I mean, the code of ethics has so much to address, and the sections that we're going to be going over today are going to span over from duties to the public, and then also duties that we have to other realtors. So these are questions that I get asked, and I'm sure Ken does as well, all the time, that if we have a better understanding, it helps us know what we can and can't do, and I guarantee it'll be part of your daily routine of what's there. So I'm sure we're going to have other people that are going to continue to join, but let's go ahead and kick this off. Let me go ahead and share my screen. And let's see. All right, Ken, are you able to see that?
Yeah, looks good.
Okay. Let's see here. All right. So we're going to, hold on. Just because the way this layout works, I'm going to have to expand and make it small on and off so you guys can see what's going on. So, all right, we're going to jump in just under the duties of the public of starting with Article 10. Oh, you know what? Actually, that's not true. I'm going to back up a little bit. And so weird how this just does this. It's almost like, yeah. Actually, we're going to jump in with Article 9 first, because that's one I forgot to mention. But in Article 9, this is something that's very small, but it is so often forgotten about. It says, realtors, for the protection of all parties, shall assure whenever possible that all agreements related to real estate transactions, including but not limited to the listing and representation agreements, purchase contracts, leases, are in writing, in clear and understandable language, expressing the specific terms, conditions, obligations, commitments of the parties. A copy of each agreement shall be furnished to each party to such agreements upon their signing or initialing. So this is something that is so often forgotten, that we have agents, and I'm guilty of this in the past as well, where we ask our clients to sign documents, but we never give them copies of those documents, whether that be their purchase agreement, whether that be the buyer broker, exclusive right to sell, anything that they're signing or initialing, we are required to give them a copy of that document. And so we need to make sure that's happening. Now, obviously, if they're doing electronic copies, a copy of what they're signing more likely will be already distributed to them. But if it's not, you need to make sure that we send that to them. It's pretty simple and straightforward, but we forget that all the time, and it's such a simple one to do. So
Rob, the response I get to that all the time is, well, it's in the loop.
Okay, yeah,
That's the justification is I don't need to deliver a copy to them because there's a copy in the loop. So it's there, they have access to it. So mission accomplished.
yeah, and I would go back to kind of that push-pull type of a mechanism. We all know we have, my answer to that would be, we've got agents that are within our company that don't access .loop very well, and that's the way that the agent is supposed to keep the company updated with information. And a lot of agents, I don't know how to use it. So how do they expect the client to be just able to go in and access that information or withdraw it from .loop? We need to provide that for them. So I keep going. I don't know. There's a lot of takeaways I can have from that. One takeaway is we're constantly right now trying to defend our commissions, why we are worth the money that we're being paid. And yet on another avenue with what you're talking about, Ken, is we keep hearing responses from agents that indicate that all they're trying to do is not want to do their job. How can we claim on one side that we're worth the large amount of money that we're charging when we're unwilling to do the things that we need to do our job? So I think, cutting right to it, I think that is a very weak answer and response. It's laziness, and I'd probably call that out. So if my guess is that the people that are on this call probably are not one of those people that are saying that stuff. So it's hard to get that message out. But I would say that, yeah, that's laziness, and we shouldn't take that approach.
Yeah, it's just like with the listing documents, on section 7, the listing agent has an obligation to deliver those documents in section 7 to the buyer's agent. But the practice, some agents' practice is just to attach them to the MLS, and they consider that satisfying that requirement as well. Oh, well, they're on the MLS, so they're there for you to go find. But that's not the language. The language is that they need to be delivered.
Yeah, you're talking section 7 of the REPC, not
Yeah, the REPC.
Article 7 here. So
Yeah.
yes, exactly. Okay, thank you. Anyone else have any comments? Please feel free to jump in and ask away. All right, let's go. Article 10. This one's seems like it's pretty simple, but many times people will ask a couple of different questions on certain types of discrimination. So this jumps into: Realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. And then it does the same thing below. And realtors in their real estate employment practices shall not be the same. So basically, we shall not discriminate. Now, remember, discrimination only includes protected classes. So just be mindful of what that is referencing. We were in a training yesterday, and the topic came up whether or not a buyer or a seller has a right to choose if they want to disclose all of the, let's just say a seller receives 4 offers, and the seller would want to disclose all 4 of those offers to offer number 1 and not disclose it to the rest of offers 2, 3, and 4. And the topic just came up whether or not that was discrimination against that buyer. Well, a buyer in itself, just as a buyer, is not a protected class. The seller has the right to go ahead and disclose anything they want to one or two of the parties if that's of their choosing. Now, they cannot discriminate based on a protected class. So if they're choosing to disclose information because they have information that would be a protected class, well, then that's a different story, but we're not talking about any of that. So hopefully that answers that question. Okay. Article 11. Now we obviously got several articles that we're going to dive into some other examples. So I'm trying to thumb through these relatively quickly, but the key things we're going to go off of, as I said, get a lot of questions about these particular topics. So Article 11, the services which realtors provide to their clients and customers shall conform to the standards of practice and competence which are reasonably expected in the specific real estate disciplines in which they engage, specifically residential real estate brokerage, real property management, commercial and industrial real estate brokerage, land brokerage, real estate appraisal, real estate counseling, real estate syndication, auctions, in international real estate. Realtors shall not undertake to provide specialized professional service concerning a type of property or service that is outside their field of competence unless they engage the assistance of one who is competent on such types of property or services, or unless the facts are fully disclosed to the client. Any person engaged to provide such assistance shall be identified to the client, and their contribution to the assigned should be set forth. So what is this? What do these two paragraphs basically say? We get this all the time. Our license allows us to sell real estate anywhere in the state of Utah. Not in Idaho, not in Wyoming, not in Nevada, in Utah. That license allows us to sell commercial, allows us to sell residential, vacation. We have a license to sell every aspect of real estate in Utah. However, this paragraph goes and says, part of our fiduciary duty, we have to take reasonable care and know what we are talking about. So this particular article breaks it down. We go into the next standard of practice. Be knowledgeable about the type of property being valued. Number 3, be familiar with the area where the subject property is located. So we'll get here, if I live up in Salt Lake area, and then all of a sudden a family member of mine has a friend in Fillmore, and they want me to list the property. Can I list it with my license? The answer is yes, I can. But my knowledge of Fillmore consists of I-15 between Salt Lake City and St. George, and the gas stations that are right off the side of the road. Other than that, I have no knowledge of Fillmore. I don't. So for me to list a home in Fillmore, I don't have the knowledge or experience to give the seller the type of service that they are owed. However, it says, unless you disclose information, if that family member of mine gave me that referral and I told him, hey, let's just say it was Ken was the person, and I were to tell Ken, just so you know, I've obviously done real estate for many years. I've never sold a property in Fillmore. I really don't know much about it. I can pull up comps and see what things are going for there, but I'd hate to have you lose out any value because I'm not familiar with the area. But Ken, he trusts my family member explicitly, and he understands that even though I don't have the experience, he'd rather have me list that property than work with any other agent. Great, I've disclosed that to him, and Ken knows the risk. There's no problem with me listing that property at that point if Ken would still want me to represent him. That is perfectly fine. Same thing going with commercial. If my business is all around residential, but I don't have any experience in commercial. Legally, I can sell that, yes, but I don't have the experience or expertise. I've got to disclose that to the client. If the client understands, hey, I get it, and I know that because you're going to list, you've agreed to, let's just say I take the listing, and instead of a 6% listing, I take a 5% listing. And they're getting a discount now because they know that I'm not as versed in that area. And that's the reason why they're getting a little bit of a discount, because I'm not as knowledgeable about it and they understand it. Great. Go ahead and get it in writing that they understand that we've covered this, so that if something does go wrong later on, you're not going to be put in the hot seat. Ken, did you have any thoughts to that?
No, that's a great point. And it even gets more complicated than that, because some areas that we may be asked to do business, for example, Park City or Summit County or Washington County, they have their own MLS systems. And so we don't have access to all of the comparables in certain markets in the state because they have their own MLS system and we're not members of that MLS. So you're going into a situation where you don't have all of the data that you need in order to help the seller or the buyer make an educated decision, because you don't have all the comparables. So it even gets more complicated than that. What are there, Rob? 5 or 6 MLSs in the state?
I believe so. So yeah, I'm on 4 or 5. Yeah, pretty much. Yeah.
I think we have the misconception in our minds that just because it's on the Wasatch Front MLS, that's everything in the state. It's not. It should be everything that's along the Wasatch Front, but it doesn't include other parts of the state or the Wasatch back. So just keep that in mind too, is that you don't have all the information that you need to help your client. So, enroll an expert who's a member of that local MLS and local board.
Any questions about that? I'll just add, I've had agents in the past where they've even said they've listed a property that was 2-3 hours away, and somebody's calling, or they either list the property or they have a buyer that started out wanting to look in an area that they actually work, and then they decided, if they can't afford where they currently are, let's just say we're in Salt Lake, and now my buyer decides they want to go to Fillmore, and that agent continues to work with that particular buyer, but now the buyer's calling up, hey, I want to see this property. Hey, you know what? I need more notice to show you the property because I'm 2 hours away to get there before I can even meet there. And so now again, that ability to offer reasonable care for the client may not be there when we are choosing. Again, it's our choice if we're going to do this. Same thing on the listing. I've had agents that have taken a listing in Vernal, for example, and they work here in Salt Lake, and they got to show the property, and they'll either ask another agent out there if they can go, show the property for them because it's 2.5 hour drive, or vice versa. They're going to take the buyer and then they're going to ask the listing agent out there if they can show the property because it's a 2.5 hour drive. And I'm like, hold on a second. If we decide that we want that business, well, then we've got to do the work that encompasses all of that work. If it's a 2.5, 3 hour drive and you're choosing to represent them, well, then you make that 2.5, 3 hour drive to do the job and make sure your client understands that that's part of the, if they want to continue to work with him, that's going to be a consequence to it.
Hey, Rob, I got a question on that one.
Sure.
So, I get the fact that, you have to do some work to do that, but it also says in that article that you can have somebody help you who's competent in that area. So I kind of look at it as like, if I have somebody who is in a certain area and they can help me show the property and they're competent in that area and they know that kind of stuff, that seems like I'm invoking that part of the, where they can actually help me through the process. Now, I know contracts and I know I can write a repsy for it and I might consult with them on some level. I kind of see that as fulfilling that. Am I seeing that wrong?
No. And I appreciate you bringing that up. That part would be true. Let me expand the example. So Jason, you live in Fillmore, you work there, and I contact you. I think the part that's being missed is the agent. Like if I'm that agent and I contact you, hey Jason, would you mind showing this property for my client down in Fillmore? Do I plan on compensating you, or do I just expect you to do that work for free? The article doesn't say that I have to pay the agent. If I'm asking for another individual that is an expertise or has expertise in that area or field, I don't think that other person is expecting to work for free. But yet the person that is oftentimes asking does not want to compensate. Or if they choose to compensate, here they're going to get a $15,000 commission. They say, yeah, I'll pay you $250, $500 if you can open up a door. Well, it's more than just opening up a door. We don't get paid based on kind of an hourly basis. We get paid because of our knowledge, expertise, and everything that's there. So,
well, regardless of whether I pay them or not, it fulfills the obligation of me at getting somebody competent in that area. So I agree, somebody shouldn't do the work themselves. However, let's say they choose to do it for free, or I, as an agent, won't offer them any money, but they are an expert in that area and they consult with me. Am I not fulfilling, like, it might not be nice, but I'm fulfilling that, right?
Yes. And so I guess where your question is being brought up, I'm expanding this from outside of the code of ethics. So yes, on the code of ethics piece of it, you are fulfilling that. Okay. Now I'm just adding more of a professional courtesy addition to this. The code of ethics does not talk that it has to include compensation in this area, or whether the work's going to be done. But I'm just saying this as an addition. If you were to call me up you were in Fillmore, hey Rob, will you show my client, because I'm taking this business on and I don't want to, in essence, do all the work, but I don't want to lose the client either. So Rob, I'm going to ask you to do the work for me so you can get paid. I'm saying that is not a business practice that too many people are going to buy into. Obviously, agents still try to do it. I know people contact up here or up north. They contact St. George all the time. Hey, will you pull up some comps for me? Will you do this? Will you do that? Well, that's the stuff that I would say anyone down in St. George, I would say, no, I'm not going to do all the work because you're choosing to not either pay the MLS to join their MLS to do the homework, but you're trying to expand your business model and not compensate me to do your work. So we're talking about two separate things. Hopefully I've answered your question, Jason, but yes, the code of ethics says you got to seek other one's help, and your point absolutely accomplishes that. The next avenue of it is just professional courtesy.
Well, let me throw another wrinkle in there too, and that's about the compensation as well. Often agents will strike a deal with an agent in the scenario that you're talking about, and they'll say, "Oh, I'll send you a gift card, or I'll send you a check for doing that." All compensation needs to run through the brokerage, so we can't cut deals directly with the agent to compensate the agent directly. That compensation needs to flow through the brokerage, through their brokerage. And that often gets overlooked.
Great catch. Absolutely. any real estate services must be paid to their brokerage.
And I think a lot of agents think, oh, if I'm doing a gift card, that's not cash, so that doesn't apply.
Yeah, thank you. That's a good point. And it's not that some people think, well, you're just saying that so the brokerage gets money. No, even if the brokerage didn't make a single penny on it, it's still, the state law requires that all compensation is paid through the broker. So good point. Okay, thanks for bringing those questions up. Article 12. Let's talk. This is one of the key things that is often missed. And it deals with our advertising that we have as agents. So realtors shall be honest and truthful in their real estate communication and shall present a true picture in all their advertising, marketing, and other representations. Realtors must not represent that their brokerage services to the client or customer are free or available at no cost to their clients unless the realtor will receive no financial compensation from any source for those services. Now this standard of practice was just updated this year in January. So I know it's been a common practice of a lot of buyer's agents. They'll say, oh, you don't owe me anything. My services are free because the seller's going to pay for it. Well, we can't say that anymore. You can't say that my services are free. If you use the term my services are free, you truly cannot be getting any compensation. And if you're not getting compensation, then sure, you can say it's free all day long. Now, the way that you would say that, the way that you would ultimately say, typically, the way that the compensation is taken care of is the seller has entered into a listing agreement with the listing brokerage, and now they're going to offer compensation across the MLS and show them where it is, and that's where my services are going to be paid for, buyer. So we've got a buyer broker for 3%, and if it's the 3% is being offered on the MLS, there won't be anything else required of you. Now, hopefully some of you guys are doing this. If the compensation on the MLS is less than what your buyer broker agreement is, then I think someone either has their mute off or.
Oh, sorry, it's me, Rob. I just had a question for you.
Oh, yeah, jump in there. Go ahead.
I was curious, can you say that we work for free until we're successful? Is that?
Nope. That was one of the big changes in January. You cannot use the word free at all unless you truly are not getting paid any money. So let me read that part again. Realtors must not represent that their brokerage services to a client or customer are free or available at no cost to their clients, unless the realtor will receive no financial compensation from any source for those services. Did that answer your question, Nathan?
Well, because I'm wondering, I mean, if you said we worked for free until we're successful, I feel like that's being completely honest, that we're not asking them to pay us until we find them the home that they want and they're successful in getting that.
I understand where you're coming from, but more so because of now that they made the change, the word free is what brought this entire conversation up. So they're very clear on the word, using the word free. It is not able to be done unless you're not being paid anything. So you got to tweak what you're saying now. It's just, look, the great news is you don't need to pay me anything until we actually close on the transaction. That's when my commission will be owed. Now, on the listing side, that's actually untrue, because once you list the property and they find a willing and able buyer, that's when that commission is actually owed. Now, they may not actually pay it until we close on the transaction. So, but the list side versus the buy side is a little bit different. So you are gonna have to tweak what you're saying when you're representing a buyer. Because I'm not gonna ask for any monies from you until we actually close and get you inside the house. At that point, that's when the commission will be owed. Now, the great news is this: oftentimes that commission, and most of the time, that commission is probably going to be paid by the seller.
Cool. I like it. Thank you.
Does that at least that solves the problem for you?
Yep.
Okay, good. Any other questions about that? All right. Article 13, very simple. It's just talking about offering legal services. Realtors shall not engage in activities that constitute the unauthorized practice of law and shall recommend that legal counsel be obtained when the interest of any party to the transaction requires it. So it's a very simple article, but I'm sure, and again, I'm sure I'm probably guilty of it as well in the past. I'll speak for myself. I'm not an attorney. So my guess is most of us in real estate are not attorneys. And therefore we don't have the ability to provide any legal advice. Yet we are constantly put in positions where our clients ask us for legal advice. And we're trying to provide all these services for our clients, and understandably, we don't want to just pass them on to somebody else, because that's why then the client may think that we're not worth what they're paying us. And I get that. So I think the standard answer that I will provide is a constant reminder of that. If Ken were my client, is asking me for certain things, Ken, it's a great question. As I want to remind you, I'm not an attorney. I can't give you any legal advice. You certainly need to go and get whatever professional advice that you need, whether that be an attorney, an accountant, an engineer, a contractor. What I can share with you is my experience. I've typically, and this is where you've got to be careful. We talked about an example yesterday where some agents, I think it was June down in St. George. She brought up an example of something that happened down in St. George where a buyer was buying in a particular area, and the agent happened to say that oh, you don't have to worry about where this home is located. It's on very stable ground, and there's not going to be any issue with foundation or whatever. So they took on this engineering type of a position, and sure enough, the homeowner bought the home, and 3 to 5 years later, I don't know the duration of time, all of a sudden additional settling started happening. The house basically started to separate, and that agent and brokerage ended up being sued. My understanding that they won because they relied upon that opinion of that agent. We've got to be careful. What hat do we wear? We are being, under our company, we're being hired to market it and assist in facilitating the transaction. You are not employed as contractors. You're not employed as engineers. You're not employed as attorneys. And so, and some of you might be contractors. And from the company's perspective, if you are a contractor, you got to remember which hat you're wearing when you ask questions. Are they hiring you as a contractor? If that is the case, then you're not Rob Oakey at Everest when you're giving that advice. You're Rob Oakey at Contractor LLC, and that's a different license that is going to protect that. Now, so you got to remember which hat's being worn. Okay, any questions about that? All right. Article 15. These are duties to realtors. So we've now shifted out of duties to the public, duties, and now we're shifting to duties to realtors. Article 15 is very easy to understand of basically just not bad mouthing, talking poorly to other realtors. We have an obligation that we cannot make any false statements. We can't make any false accusations about them or their business. And we can't file any false ethics complaints that just because that person upset me. So we just got to make sure that we are, running a business that's honest in everything that's being done. I don't think we need to go into too much information about that, but any questions about it? Okay. Article 16, this one's kind of this basically is the last one that we'll go over, but this one's a big one because we get this one on everything dealing with agency. Realtors shall not engage in any practice or take any action inconsistent with exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients. Okay, it's like, what does that paragraph even mean and say? So let me go to the first one. I think it's up here. So sorry, this is what drives me crazy. This keeps jumping from one page to the next. All right. Okay. What this first part's talking about, it's telling you things that what the article is not intended to do, and some of the things what the article is intended to do. So the first part, 16.1, Article 16 is not intended to prohibit aggressive or innovative business practices which are otherwise ethical and does not prohibit disagreements with realtors involving commission fees, compensation, or other payment expenses. So again, they're using the word aggressive that's there. Do you have the ability to reach out to people and do certain things that one side may say, oh, that's very aggressive in your approach, but yet you're very professional, it's very honest. Just because you're not taking no as an answer means that one person may think you're violating the code of ethics, or a consumer may think you're violating the code of ethics because you're talking about listing their home, and but you're being very professional. You're not being condescending. You're not disagreeing with what's being said. You're just having a conversation. It doesn't prohibit that. Now, one thing you got to be mindful of is there may be state laws that have like telemarketing laws in place that could conflict with this. In Utah, this isn't a conflict in this, so it's not going to be an issue. It does not preclude from making general announcements to prospects describing their services on the terms of their availability. But this is what it does. Article 16 is intended to recognize unethically two basic types of solicitations. First, telephone or personal solicitations of property owners who have been identified by a real estate sign, multiple listing compilation, or other information services as having exclusive listing their property with another realtor. And second, mail, or other forms of written solicitation of prospects whose properties are exclusively listed with another realtor when such solicitations are exclusively listed, or sorry, such solicitations are not part of a general mailing, but are directly, specifically to a property owners identified through compilations of current listings, for sale, for rent, signs, otherwise, other sources or information required by Article 3. Okay, like what does that whole thing mean? If there is a for sale sign in a yard that says it's with Rob Oakey at Century 21 Everest, and Ken calls on a list that's on the house and looking to list my property that's already listed, that's what this is talking about. Or, and we've had our own agents be guilty of this, and it was unintentional. They sent out a mass mailer to a bunch of an area, a geographical area that they're asking to buy their house, and I'll even say their mailer made it sound like, look, it was pretty clear. It did not say that they were looking to list the property. They were looking to buy the property. And anyway, the homeowner and the agent that received that mailer, they cited this article, and the panel, when we went to represent, the panel found our agent guilty of it, of violating this code of ethics, because they sent in a mailer that to a home that turned out to be listed already on the MLS. Ken, do you have something to add?
Yeah, this is a big problem. We run into this problem all the time, especially when, agents are sending out mailers to their farm areas. We encourage that. You guys should be working your farm areas, in several different ways, but not all properties that are for sale have a for sale sign in the front yard. The seller can choose not to have a yard sign. So just driving a neighborhood, there may be a house in there that's for sale, but they've just elected not to have a yard sign. So it's only on the MLS. It's really easy to get away from having a problem with this if on all of your mailings, you'll put the language, this is not intended to solicit a property that is currently listed. That little sentence right there will go a long ways to preventing the kinds of ethical complaints that we've had in the past. So if that is part of your business plan to send out mailers, you need to have those reviewed. I'm happy to review them. I'm sure Rob is, but you just need to make sure that they're compliant so that we don't get those kinds of cases.
Thank you. Great, appreciate that. Okay, the other question that we often get, and what's so interesting is when I'll have agents ask a question, hey, I've got a client that is asking me to represent them, but they've already signed an agency agreement with somebody else. Can I represent them? And if I ask that agent the question like, well, what if you were the agent that client has signed the agreement with? Do you think you should be able to let another agent be able to work with your client? So on one side, when they're potentially the beneficiary of it, they're like, yeah, hopefully I can do this. But if they're the ones they're the one that would be penalized by having that same rule apply, they're like, well, no, it shouldn't be able to do that. So it's always fascinating. I understand we want to be able to make money, but just use some common sense. So this first part of it is realtors shall not solicit a listing which is currently listed exclusively with another broker. However, if the listing broker, when asked by the realtor, refuses to disclose the expiration date and nature of the such listing, i.e. an exclusive right to sell or an exclusive agency open listing, the realtor may contact the owner to secure such information and may discuss the terms upon which the realtor might take a future listing, not current, future. So what that means is I ask Ken, I first got to call the broker. So Ken is the broker on this listing. Hey, Ken, I'm just calling on your listing that you have on 123 ABC Street. I mean, this should be on the MLS where it shows that it's going to expire, but if it's not, I'm just wondering, I saw the sign in the yard and I don't see it on the MLS, which now because of the MLS policies and procedures, it's kind of changed. It makes this hard to do. I can't even think of a way where this would come up that I don't have the information already. But regardless, Ken, I'm just wondering when your listing expires, and is that an exclusive right to sell or is it an open listing? And now let's say that he says, I'm not telling you that.
None of your business.
None of my business. Interesting. Well, you know that Code of Ethics would say differently. And he says, no, it doesn't. I'm not telling you that. Okay, well, then I have the right to contact that. So do you want me to contact your seller and ask him the question? Because the Code of Ethics allows me to do that. You do that, I'll file a complaint against you. Okay. So now I go knock on their door, and this I will say, I'm going to make sure you caution the wind, because when we talk about this, people are thinking, you mean I can go talk to existing clients about this? I'm like, hold on a second. Just be very careful when we're going down this road. If I were to do this, I've got to do exactly what the article talks about. And that is, now Ken's the buyer, hey, or the homeowner. Hey, Ken, my name is Rob Oakey with Century 21 Everest. I understand that you're currently listed with John Smith with ABC Real Estate. I'm not here looking to interfere with your current agency relationship. I'm asking, when does your listing expire? It expires June 1st. Okay, June 1st. So Ken, I guess my next question, on when your listing expires on June 1st, so June 2nd, if your home is still on the market, I would love to interview for the job of listing your home. And I'm happy to share with you what I can do if that on June 2nd, if your home did expire, what that business would look like. Do you have a moment we can sit down and talk? And
Yeah.
Nowhere in my conversation, when I go talk with the agent, because the client would say, well, that sounds great. If I can get out of my contract now, can you list my property today? I said, I'm here solely when your listing expires, which you said was on June 2nd or June 1st, what I can do when your listing expires. Again, I can't talk at all about anything what I'm able to do with a current listing, because that's not why I'm here. I'm here only to talk about what that business would look like when your listing expires. I'm not going to wait. Well, can I contact the other broker to get out of my current listing? That's a conversation you have to talk about with your broker. I am not going to discuss that whatsoever. Now, know this, where this is an area that can be sketchy water. Can that seller come and make an accusation or a claim that when I was there talking to them, we talked all the time about how to get out of the listing or how to do current business? The answer is yes. It's a he said, she said. And if I'm in their house giving a listing presentation while their home's listed, and the seller is claiming that I'm talking about taking a current listing, I'm in a tough situation. So just be mindful that even though you have the right to do it, I've personally never done that. Now, I have had clients call me and say, Rob, we got your name from this or from this resource, and we'd love to have you come list your home. Well, I'm showing it's already listed. Yes, it is listed, but we want to interview new agents. I'm like, hold on a second. I'm happy to help you once your listing expires. When does your listing expire? Okay, if you're reaching out, I can talk to you literally about everything in the future. And I want to send you an email making sure that you're going to confirm that that's what we're going to talk about. Now I've got some guidance to protect me from something happening. So just be careful of what we're talking about.
Yeah, and the tricky part of that, Rob, is under the first scenario, you've got the seller and the agent saying that you made representations about the current status of their listing in a complaint, and you're going to lose every time if you've got the seller and the agent saying the same thing, that you solicited the listing away. And because it's their word against yours, there's two testimonies versus one testimony. So it is a very slippery slope there.
If I ever did that, I would record the entire meeting. I think that's a little scary.
It is.
But
That's one you got to try.
you just got to cover yourself.
Yeah, okay, we're running out of time, so I want to make sure that we cover at least one piece here. Let's see. It's not what I'm talking about. I want to make sure that we address. Oh, there it is. Okay, that's what I wanted to get. We're going to end on this one. Article 9, Standard Practice 16.9. This is the common mistake that when agents are asking, can I get in or out of or can I work with this client? If a client comes to me and says, hey, I'd like you to show me this property. Oh, how'd you find out about the property? They said, oh, I've already seen it briefly on the inside. Oh, great. Yeah, happy to show it to you. And I don't ask any other further questions. Well, when we come across potential clients, we have an obligation that we have to ask certain questions to determine if that client is already in an existing agency relationship. So 16.9, realtors, prior to entering into a representation agreement, so prior to signing a buyer broker or a listing agreement, have an affirmative obligation to make reasonable efforts to determine whether the prospect is subject to a current, valid, exclusive agreement to provide the same type of real estate services. So if a client calls up my phone number, wants me to show them a property, and I say, sure, happy to show it to you, and I don't do anything else, I'm in violation right off the bat because I haven't even made any effort. Or they say, now let's say that I ask a question, are you working with any other agent? Now the client says no. My opinion, and then you say, great, let's go look at something. Well, my belief is you should ask an additional question if you're doing that. If you say, are you working with another agent? No, I'm not. Okay, great. So are you telling me you have not signed any other agency relationship or buyer broker with another agent? No, we have not signed anything. Now, if you ask those questions and they tell you no, you haven't done anything wrong. The client themselves has put them in that situation. And I mean, that's on the client. But if that buyer tells you that they've already made a couple of offers on other properties and then they say they haven't signed anything, that in itself doesn't make any sense. So we have an obligation. If they say, no, I didn't sign anything, and you just say, oh, great, but yet you knew they made other offers, that's where you got an affirmative obligation to do some more legwork. I would, if Ken were the buyer, I'd be like, I'm a little confused, Ken. So you're telling me you've made offers on one or two other properties and you've never signed a buyer broker agreement?
Yeah, they sent over the offer, but I didn't sign two agreements. I just signed one. You know,
Okay.
so often what happens is the buyer, the buyer's agent will include the buyer broker agreement as part of the REPSI in one package, and they don't understand the difference. They think
Exactly.
they've just signed one agreement.
Exactly. Or, I mean, it is possible, which the agent doing that would be in violation if they didn't sign something, or the other thing is that the buyer broker may have been property specific. Okay, well, just ask, hey, do you mind give a copy of that offer that you submitted? I just want to make sure that I don't step on any toes. Would you mind sending the paperwork so I can see whether or not you actually have signed a buyer broker? And if you get a copy of the buyer broker, it's property specific, great. Go have at it. Go and show them another property. But if it turns out that they do have a buyer broker, yeah, you're not able to move forward on that.
That's a great point, Rob. Ask for the paperwork. Review it yourself because you know what you're looking for. They may not know exactly what it is they're looking for. So
It ends up being, I mean, it's a just so you know, we're always trying to help you to see how that is going to look. And when you're you're trying to get business at the same time, when another agent and another brokerage is trying to take the business away from you, I'm trying to defend. We're trying to do everything we can, but we have obligations that we have to perform, whether we have the client or not. So we need to make sure that we're doing our job if we're asking other companies to do theirs. So hopefully that, I know it's kind of a lot of information there, but hopefully that provides some answers to some questions that you might have. Any other questions before we sign off?
no, it's a great job. Those are very, very important points.
Okay, guys, we appreciate you attending. Hopefully everyone's finding that the link that has been sent out is also going to be more helpful. And these recording, we're going to start recording these as well. And this one was recorded, and they're available on YouTube as well. So you can always come back and review these if necessary. So otherwise, guys, we'll go ahead and sign off, and you guys enjoy the rest of your day.
Thanks, Rob.
All right, bye-bye.
Bye.